Well, welcome everyone to ALTA's latest ALTA Insights webinar. These are our free presentations we offer on issues important to title and settlement professionals. I'm Jeremy Yowie, ALTA's Vice President of Communications, and today we've got a great webinar lined up to discuss the revisions to these ALTA loans and owners policies, as well as some of the other ALTA forms. This topic really hits at the heart of what you all do every day, and hopefully this will help you explain how these changes will affect your customers. We've had over 1,000 people register for today's presentation, so thank you all for taking a little time and joining us today. All right, before starting, I do need to touch on a few housekeeping items. All participant lines are muted for today's discussion. If you have a question during the presentation, please submit them through the questions box, and we will hold some time for Q&A at the end of the presentation. As a benefit, the webinar is being recorded, and the recording will be available on ALTA's website at alta.org/webinars. That's alta.org/webinars. You'll also get an email tomorrow with a link to the recording. You can also download a copy of today's presentation in the handout section. And it should also be noted that today's webinar does offer CE and CLE credit for many states. Credit's only available for those attending the live presentation, and our platform does track attendance. To meet compliance with state requirements, there will be some poll questions during the webinar monitoring attentiveness. So pay attention and no multitasking. We will use the information you provided to report the attendance. Any questions for CE, CLE, please send an email to education@alta.org. We do need to thank First American for sponsoring today's ALTA Insights presentation. And before introducing today's speakers, here is a short message from First American. All right, well, that was a nice message. Thank you, First American. Now, let me introduce today's speakers. Joining us today, we have the luxury to hear from two industry veterans who have served many years on ALTA's Forms Committee. First, we have Paul Hammond. Paul is Senior Vice President and Chief Title Counsel for First American. Paul is Chair of ALTA's Forms Committee. And also joining us today is Jim Gosden. Jim is Senior Vice President and Associate General Counsel for Stewart. Jim is the immediate past chair of ALTA's Forms Committee and served as chair for many years. So I want to thank both for their service to the industry and constantly reviewing the forms and helping meet the needs not only of the industry and our customers. And with that out of the way, Paul and Jim, thanks for joining us today, and I'll turn the keys over to you.
Well, thank you so much, Jeremy. And I'd like to personally thank Jim as well. My partner in crime, you might call him, as we've worked so closely together for so many years, enjoying this labor of love we call ALTA Forms and the ALTA Forms Committee. Jim's devotion and those that supported him within Steward Title Guarantee was second to none, and so very much appreciated. And really appreciated is the fact that Jim is still going to remain very active on the Forms Committee in his role as media past chair, part of our ALTA Forms Committee leadership team. And Jim, thanks so much for all that you do and have done, and just for your friendship. So here we go, my friend.
Okay, thank you so much, Paul, and it's been a joy to work with you and all the other members and observers on the Forms Committee. And that brings us to the question how these forms get adopted now. We have the Forms Committee itself that has subcommittees, and then we have full committee review of proposals. And so we first go through the process of making changes to the forms through the subcommittees and the committee. And then we have to report whatever we recommend we do to the ALTA board after corresponding with the underwriting section as well. So what we have done is lay out proposed forms, and that's not simply the ALTA owner's policy and the ALTA loan policy, but primarily, and that's our focus today. And we have those forms on the ALTA website, and we request public comments be made by December 31st of this year, although it is always conceivable there may be some comments after that period. The proposed effective date for these forms is July 1 of next year, and we are hopeful that that will be the date indeed when they're adopted, which is of course not the same as the date that they'll be available in a particular state. Paul, do you have any comments on that?
Well, yeah, looking back at that very first box on this particular slide, the process is ongoing and begins with an idea. It might interest the audience to know that the ink was barely dry on the 2006 forms when we started making our list with ideas for things that the Forms Committee members anyway felt we would probably want to attend to when we next get around to revising the 06 forms. And here we are.
And here we are. Next PowerPoint. Awesome. Thank you, Jeremy. Well, you can see by looking at this PowerPoint that there were a lot of title underwriters involved in this process. Not all of them are currently participating, but there were many that were, and we have had some overlap between the original members and observers and the ones who are currently working on the forms. So we've had a lot of involvement. You see, for example, the second point is there have been 20 plus title insurers that were represented. We've tried to have a broad array of underwriters and underwriting companies involved in this process. And I think Kelly particularly has been important and helpful in seeing that that is done. We have the underwriter section that also has been reviewing and giving us guidance. And we've had several occasions where we've been provided guidance from the underwriter section. And of course, we each work for an underwriter, so we have their guidance too. And then there's the Board of Governors that have approved these forms tentatively, I say, and effective July 1st next year. Now, what's really interesting is we've had outside input, and I know Paul will want to comment on this too. For example, we had ACMA, American College of Mortgage Attorneys, a number of comments from the American College of Real Estate Lawyers, FHFA, Fannie Mae, Freddie Mac, MBA, and other lenders, and we've had individual attorneys provide guidance to us. Paul, what do you think?
Yes, we have. I think it's unique in our line of insurance, the extent of engagement that we have with our customer groups every time we make what we consider to be any sort of material revision or change to our product forms. In other lines of insurance, it's been my experience anyway that they just change their forms willy-nilly, and their customers are sort of stuck with it once any given insurer decides it's going to add a new exclusion or pull back on a covered risk or something of that sort. So that is not the way we've historically worked in the title insurance industry. There's many reasons for that, but the input we receive from these groups are invaluable. And when you talk about customer comments, the list there at the bottom obviously represents a group of outside customers, but we have thousands upon thousands of what I'll call internal customers to the title insurance industry that are often not very shy about offering up their comments. And those sometimes come from groups within state land title associations. I know that my friends on the CLTA Forms and Practices Committee have been very active in reviewing everything we do at the ALTA Forms Committee level and offering up their substantive comments, and we appreciate that greatly. Other state land title associations have likewise been not shy about offering comments, and at the end of the day, just as we believe to be true of the Forms Committee membership in general, it's true when we pull in all of our constituents that we are all better together than any of us are individually, and we value all those comments.
Well,
Next
that's
slide.
true. We definitely had comments from claims attorneys too, and that provided some good guidance for us.
We did, and I just for a moment, Jim, I know you feel this way as well. I would really personally like to thank all of our Forms Committee member friends and colleagues. It has been a collective labor of love. I mentioned at the top, you and I certainly consider this to be a labor of love, and we better, right? Because it drags us away from family. It drags us away from day jobs in our effort to help the industry and get things as right as we can within the four corners of our products. But while there are many underwriter folk that are a part of our Forms Committee, there are also some very high level and experienced claims representatives on the Forms Committee these days, and they have been invaluable in helping us stay on task, but also to recognize the importance of precision that we always strive for. But no matter how hard we try, sometimes left to any one of us in coming up with a clause we're drafting, it can be looked at a different way, and it's good to have the input of experienced claims people who see this come alive before judges and juries in real life claim situations, recognizing that sometimes while we think we say what we mean, it isn't always understood that way.
That's right.
So why the heck are we doing this, Jim?
Indeed. Well, I'll give you a couple of examples. And for example, we've had developments in case law. Now that has helped inform a particular portion or provision in our policies and the conditions with regard to loss. We've had the development in the respect to the Dodd-Frank law. Dodd-Frank and thereafter the Consumer Financial Protection Bureau. Those were important changes. And if you look at our current proposed forms, you'll see that you can glean in some respects the definition of consumer protection law as being informed by those changes. We have remote online notarization, which you'll see, for example, first of all, in Section 2 of the covered risk with reference to, as well as in Section 9, as I recall. And then we also have the Uniform Voidable Transactions Act. So that helped inform how we wanted to view the creditor's rights, covered risk, and exclusions.
Excellent. Next slide, please, Jeremy. Whenever we talk about a title insurance policy, just as I suspect is true for any of you in the audience that train to our products, it's helpful to just go through section by section. So that's what we plan to do today, beginning with the covered risks, moving into the exclusions, then the all-important schedules A and B, on into the conditions, and then on new and revised definitions. Those are part of the conditions section, condition 1 in particular, and we'll try to highlight some of those new definitions as we go through sections of the policy that use the new defined terms. And on we go. Oh my gosh, here we are, covered risks. So Jim, you want to talk about covered risk 2?
Sure, it's one of my favorites. So you have 3 portions of covered risk 2. Now, just look at the first line. Any defect in or lien or encumbrance on the title. In a way, that really says it all, because what you see thereafter are matters that are illustrative. So it says covered risk 2 includes but is not limited to insurance against loss from. And then we have A, defects. We have various defects that are mentioned. That's not exclusive. B, we have lien of real estate taxes or assessments. And then not due and payable. That's how we're insuring it. We're giving coverage as to those that are due and payable, but unpaid. So insuring against that type of risk. Thirdly, we have the survey coverage. It has been reworded, but the concept remains the same. And we don't have the defined term encroachments now built into 2C. Instead, we have this language which covers the issue itself, because it covers encroachments, and it covers encroachments either onto our property or by our property owners' improvements onto adjacent property.
The important aspect of covered risk 2C, Jim, I've always believed, which is why we drafted it this way, is that first part of the phrase, the effect on the title of, right? Because when we look at surveys, we know there's a lot of stuff buried in surveys that have nothing to do with the title. And as a quote title end quote insurance company, we do not intend to insure against violations, variations, adverse circumstances, etc., unless they have an effect on the title, right?
Absolutely. And forgive me, going back to 2A, there are 2 points I see highlighted, and those are remote online notarization. Now, we already covered a defect in title with respect to notarization. It's a defect in title. Now we explicitly acknowledge remote online notarization. Were we not to do that, it would still be incorporated. We also incorporate remote ink sign notarization, whether it's mentioned or not, because that can be a form of notarization in the transaction. And we added a new provision, which is repudiation of an electronic signature, but keeping in mind so that the electronic signature was not valid under applicable electronic transactions laws.
Again, all of which is modified by the lead-in to 2A, a defect in the title caused by any of the following. And to your point earlier, Jim, again, we want to reiterate everything that's most relevant to covered risk 2 starts and stops with the first sentence. It is a very, very broad covered risk. It remains a very, very broad covered risk. The rest of it is illustrative. Why do we do that? Because back in the 92 and prior policy forms, going all the way back to, I dare say, the 1920s, we just had, that one sentence, any defect in or lien in or encumbrance on the title. It might have read slightly differently, but we didn't have all the rest of this stuff. And so one might ask, why do we now? And I'll just answer that. It's because we wanted to get credit for some of the things that clearly fall within the breadth of the scope of that first sentence that candidly our customer groups didn't always understand were covered. And I think we started this approach of illustrative types of covered risks within covered risk too back with the homeowners policy, didn't we, Jim?
Yes. So I think it's definitely improved. I think the clarity is remarkably heightened by having this elaboration. Although I do think wistfully of the 1929 loan policy once in a while, but not very often.
We can move to the next slide, Jeremy. Yes, covered risks 5, 6, and 7. These covered risks first found their way in with the 2006 policy, as the audience undoubtedly recognizes. And as you read carefully through those covered risks, you'll notice that they don't really have anything to do with title to land, more with governmental regulation or the use of land, with the possible exception of the exercise of powers of eminent domain that have actually already taken place and are binding, such as you see in covered risk 7B there. This has been, these series of covered risks have been restructured, and here's where we get to see our first new defined term, enforcement notice. As we look down at that definition, you'll see it's a document recorded in the public records that describes any part of the land and is issued by a governmental agency or the holder of a power of eminent domain, or that asserts a right to enforce a PACA PASA trust. We'll explain a bit more by what we mean by PACA PASA trust in a moment, but that is our revised covered risks 5, 6, and 7. And for my part, Jim, I truly think the wording overall of this is vastly better than it was in the 06, easier to understand, easier from a search and examination perspective to identify those documents that might be in the land records that we intend to be speaking to by these covered risks. So obviously, if they are out there and we discover them in our search and exam, the intention would be to put them in as Schedule B exceptions. Do you agree with that?
I do, and everybody should keep in mind we have more precise language now, particularly in number 5 and number 6, because I have an affection for them, because it references an enforcement notice by the enforcing governmental authority. And then under number 6, it's an enforcement notice by the enforcing governmental authority. It's not simply some blasé notice by any third party that's going to be adequate to fit precisely within that covered risk. And likewise, you have similar language with number 7, because that either involves an authority that can engage in condemnation or a governmental agency or instrumentality or body. So you have a little bit more precision here. So always keep in mind the defined term. And that's going to be true anytime you have the upper initial case. So that helps too, I think. And I think that's just one more example of how we become more precise.
Agreed. Thank you, Jim. Jeremy, next slide. I told you we'd get to PACA PASA trust in just a moment. The moment has arrived. What the heck, Jim, is a PACA PASA trust? I'll try to answer that for anyone in the audience that might not have heard that term before. It essentially is shorthand for the Perishable Agricultural Commodities Act and the Packers and Stockyards Act, the former being PACA, the latter being PASA. For anyone interested in a citation, you'll find these acts respectively in 7 USC section 499A et sec and 7 USC section 181 et sec. They are laws that have been on the books for eons to protect the rights of farmers, ranchers, growers, downstream dealers, brokers, and commission merchants having anything to do with the growing or production or sale of fruits, vegetables, poultry, livestock, and other types of meat products. Well, how does that have anything to do with title insurance? Well, the industry found out the hard way, as we often learn our lessons, that these laws exist on the books and that they're there to protect these folks, and that the way they protect these folks is very likely not to ever be noticed in the land records or discovered by our search and examination of the land records, although they certainly could be. And in their statutory regime, they impose a trust overlaying the entirety of all property now owned or hereafter acquired by anyone who owes these people money but haven't paid them. And so because we hadn't, because this is one of those areas sort of like creditors' rights, fraudulent and preferential transfer risk, it's another one of those risks that our industry has a heck of a hard time identifying and actually underwriting to in the context of specific transactions. So we have added a new exclusion that you'll see when we get to that section of the policy. But just as we do with exclusions 1A, 1B, and exclusion 2, we felt it fair to add an express covered risk to the extent that there's an enforcement notice, notifying a searcher examiner or the world as to the existence of a PACA-PASA trust. So that is what's behind new covered risk 8. And again, it's a counterpart to an exclusion that we take if there isn't something that's noticed in the public records.
Okay.
Did I say that about right, Jim, from your perspective?
I think that's absolutely correct, and I'm trying to think of a way in which PACA-PASA trust might be disclosed in the public records. I suppose one way would be a lis pendens or a copy of the pleading.
Yeah. Absolutely.
Okay.
Absolutely. I would agree with that.
X-Power.
Next slide, please, Jeremy.
Yeah. Oh. This is a covered risk for the lender that's parallel to covered risk 2A in both the owner's and loan policy, except it's relating to invalidity or unenforceability of the lien of the insured mortgage. It has the same recitals that you'll see under 2A. If you'll go to that, you'll see the same language substantially. And I point out again, we have a reference to remote online notarization because that's becoming more and more significant and important. The last item that's a new item, for example, also is 9H, which is the repudiation of the electronic signature. So everything else is substantially the same, but these are simply coverages that are included but are not limited to the items that fit within the scope of invalidity or unenforceability of the lien of the insured mortgage upon the title, because that's the coverage that's being given. Everything else is simply example.
On to the next one, Jeremy. Oh, and speaking of priority of the lien of the insured mortgage, we have covered risk 10, don't we? There are changes here. In the 06 policy, you'll notice that this essentially stops at the word title in the first line, if I'm remembering correctly. And we thought it was a little misleading because when one reads covered risk 10 in the 06 policies, without considering other provisions in the policy, one might be concerned, or one might think rather, that we're ensuring priority as to all kinds of future advances and what have you. And the fact is, because of the post-policy exclusion along with other provisions, generally speaking, it's always been the case that one needs an endorsement to pick up that future advance kind of coverage except in the context of a construction loan, which we know is covered by covered risk 11. So what we've done here with covered risk 10 is simply be more precise again about what components of the indebtedness being a defined term again, but not a new defined term, we intend to provide priority coverage for in the base policy. If there's any other kinds of indebtedness that involve any future advanced components outside the construction loan context, one would need an endorsement, presumably one of the 14 series endorsements, to pick up that coverage, right, Jim?
Absolutely. If you will look at this covered risk and you will compare it to the language in 3D of the exclusions for post-policy matters, 3D does not carve this out from the limitations of that exclusion. So this does not provide post-policy coverage, as you have noted. And if you look at the preamble of the policy, which references certain covered risks that are going to be giving or include post-policy coverage, this is not one of them. So what's the point? The point is exactly what you said. You probably need a 14 series or similar type of endorsement available on a state level.
Thank you very much, Jim. And Jeremy, next slide. And Jim, I think it's probably the case that love this stuff though we do, for the benefit of everybody and in an effort to make our way all the way through our slide deck, we're going to need to pick up the pace a little bit, huh?
Oh, I guess that means I can't talk about Jimmy Hoffa now. Okay.
No, we probably have to put that off till the question and answer period next week.
Okay. So looking at covered risk 13 for the loan, covered risk 9 for the owners. Remember, this relates to prior transactions. Okay? Prior transactions. So we're not giving coverage for the current transaction. No. That's what's excluded in the exclusions. So we'll see that later on. But there has been some tweaking on this. Why? Because the laws changed. Laws changed, and we've been, shall we say, informed of issues that we hadn't necessarily thought of before. So first of all, you'll see a reference to the Uniform Voidable Transactions Act, because that's not the same, at least as an act, as the Fraudulent Conveyance or Fraudulent Transfer Act. But if you take the Fraudulent Transfer Act, minor changes were made to that act in 2014 or so, so it became the Uniform Voidable Transactions Act. It's available in 20 states right now. So that's why we're referencing it, because it does not use the phrase fraudulent transfer. Next, we clarify the timely record the insured mortgage or timely record the instrument vesting title by referencing the date being after the execution and delivery of the instrument to the insured or delivery of the insured mortgage. So those are some clarifications, I think, that make it a bit more precise as well. What do you think, Paul?
I agree. Very, very narrow coverage is given for preferential transfer risk there in 13B and 9B. That certainly is narrow and applies in the context of the instant transaction. 13A and 9A, as you pointed out, apply to past transactions in the chain of title, not the instant transaction. That is the subject of our creditors' rights exclusion. And while the industry at one time thought it could safely provide coverage against that type of risk, we woke up to the reality long about 2010, I want to say. And in case anyone in the audience is unaware, providing that kind of coverage today would be violative of Texas law, and the exercise by Texas of its long arm powers could create some real issues for an underwriter licensed in Texas if they provided that coverage anywhere in the country. I think that's accurate, right, Jim?
That is absolutely correct. It's in the
Next
insurance
slide, Jeremy.
All right, time for a poll. And in lieu of time, we've shortened the poll question. It is not asking about all the changes right now to see if you've been paying attention. This is just a poll question to make sure everyone's still out there. Going to give you about 10 more seconds to watch this. This is important for CE, CO, so please take it, click the button. All right, go ahead and close this, and yeah, no questions about Jimmy Hoffa. All right.
Let's get into the exclusion, shall we?
Okay.
So here we are with our exclusion 1A, B, C, and you'll see references there in 1B to some words that do not appear in those forms today, but that in our view have always been intended to be a part of our governmental police power exclusion. So these are clarifying, but we thought important clarifications, again, because these are not areas that we consider our industry competent to underwrite and assume risk about. So that's exclusion 1, and you'll see at the last line there, the cross-reference back to covered risks 5 and 6. So it's excluded unless covered risk 5 or 6 picks up coverage for it. As we've already learned, coverage at risk 5 and 6, if there is an enforcement notice recorded in the public records, would pick up coverage, except then we should be taking exception to that particular enforcement notice in Schedule B. Next slide. Speaking of creditors' rights exclusions, Jim, here we are, right?
Yeah, and this is the flip side of the covered risk. It references the Uniform Voidable Transactions Act. And we also have the additional language that relates to the failure of the transaction to be made for contemporaneous exchange of new value. That's a wrinkle, and it's a bit different but consistent with the coverage and exclusion we've had.
Agreed. Next slide, Jeremy.
Oh, your favorite.
Yes, here we are with the exclusion I mentioned earlier for PACA trust. And again, you'll see the cross-reference to the specific covered risk. So if in fact there is an enforcement notice recorded in the public records to which we should be taking exception in Schedule B if we find it and it's out there, but if there is no such exception, then effectively the insured has coverage if it does exist in the public records, an enforcement notice that is, and in all other circumstances, it is excluded from coverage by covered risks 7 and 5 in the loan and owners respectively. Next slide.
Yeah. I'll make one brief point. PACA, it doesn't apply to peanuts. I know many people are wondering, and PASA doesn't apply to fish.
That's very helpful to know. Thank you, Jim. Here's another new exclusion. And Jim, this exclusion looks kind of similar to something that you've been used to including in your policies in Texas for a good many years. It just appears somewhere different than in the exclusions. Is that fair?
I think that's entirely fair. We accept 2 shortages in area if we amend the area and boundary exception. The one additional interesting reference here is a reference to a discrepancy in the area of the improvement itself.
Yes, and this is just, again, new exclusions, but put into these policies to indicate that we've never intended to insure against this kind of risk. And I would say it's mostly here because of the increasing incidence we see of legal descriptions, including square footage references, acreage references, that sort of thing, that we've, again, never intended to insure against. But if we don't have an exclusion like this and that kind of language gets left in the legal description, then it creates the potential for somebody to think that perhaps we have insured against that risk when we didn't intend to.
Absolutely.
Next slide.
Next. This is optional language. You will see it's bracketed. It could be in the Schedule A form or it could not be. It just depends. But it really is helpful for the customer to know. You see all this information listed. It's not being insured. We have a carve out in the conditions for the property address. In other words, if somebody wants to get insurances to the property address, they get it through either the homeowners or expanded coverage loan policy or by an ALTA 22 series endorsement or similar state endorsement. So these are optional. The registry ID is unique to each company, and they do not have to be a member of ALTA to have a listing.
And a word about brackets, Jim, I think would be appropriate. I'm glad this reflects the brackets. You've made clear what we intend as the ALTA Forms Committee. Anytime our policy forms come out with any sort of brackets in them, or sometimes in endorsement forms that have brackets in them, those are intended to signal that they are optional provisions. What do we mean by that? Well, we mean for each underwriter, each insurer, to make its own decision before it files the forms, by the way, in many cases, whether it wants to include that provision or not include that provision. It is best not to file the forms with the brackets in them, but instead, please take this as the direction that in connection with your individual filings, you should make decisions for yourselves as individual insurers, what should be, whether or not the provision should be or shouldn't be included. Now, once in a while, there might be a bracket in an endorsement form that is sort of there because we need to have some fill-in information. So that's a little bit different, but I just wanted to make that point about brackets. And with that said, Jeremy, you can turn to the next slide.
Okay, Paul, do you want to talk about that first paragraph?
I will. It speaks for itself and is there really to help the industry, because today in many geographies, whenever we have a Schedule B exception referring to conditions, covenants, restrictions, and the like, it is customary in many places and by many insurers to add a subparagraph to that Schedule B paragraph, but we end up doing it with every single Schedule B exception that contains any reference to a covenant, condition, or restriction. So our hope is we can deal with it one time in the heading in this manner and avoid it. The audience will remember we first inserted a clause like this in the 2016 ALTA commitment. The language has been tweaked somewhat, as you'll see on the screen. Importantly, because the law keeps changing, especially at the state level, we have a catch-all at the end, or other legally protected class, to account for the possibility that more legally protected classes will be added as we go forward, and we don't want to be changing these forms every time there's a new law out there. I will also share with the audience that we have had a number of customer comments about this particular clause, and we are in the process right now of reconsidering the language. So this is an area where you might well see a change made even to these forms before they become effective. And so stay tuned for more to come on that. And then we see added in brackets. You know what? Let's just skip that for now. Let's go to the poll, Jeremy. Go right ahead.
All right, sorry about that. I jumped the gun.
No, that's quite all right.
All right, here we go, everyone. One last poll here. Make sure everyone's still following along. So make sure you click the radio button for CECLE. It was interesting. The first poll was pretty evenly split between agents and underwriters as far as attendance.
Good to hear.
And it looks like about 45% of attendees have more than 25 years of experience. So
awesome.
All right, we'll close that poll. You got 5 more seconds, and we'll jump back into the last third or so of the presentation. There we go. All right, here you go, Paul.
We've already talked about this defined term. You'll see its references to the place in the new forms where you'll find it. Enforcement notice. I think we can move on to the next one.
I would point out just a few things. First of all, going down to 5115, which is easy to say, the grantee of an insured under a deed or other instrument transferring the title, if the grantee is an affiliate. One of the defined terms, we have several, and it's similar in concept. The parent wholly owns, or it's wholly owned by the parent, wholly owns another company, or they're both two companies are wholly owned by the same company. So affiliate, you can see a definition later, but the idea is if there is a transfer to an affiliate, the policy coverage continues. It does not condition it on lack of payment of valuable consideration. The other thing that I would think about besides that is an affiliate acquiring under number 6 that acquires title through foreclosure or deed in lieu of foreclosure of the insured mortgage. They don't have to own the indebtedness at that time to be covered.
Thanks, Jim. So the audience will recognize that over the years, we've expanded the definition of insured, mostly in an effort to close areas in the older policy forms that we learned were somewhat traps for the unwary, you might say. I'm thinking particularly in the owner's context of the numbers of transfers by named insureds to family trusts and things of that sort. That's been an issue from a claim standpoint, from a coverage continuation standpoint, and that's just one example of many where we've tried to help the industry and tried to help our customer groups by sort of broadening the definition of insured so that there are many more types of transfers that can occur without the risk of losing your title insurance coverage, or even better, where the coverage would continue, or even into the hands of a grantee. That grantee would be an insured and have rights under the policy. So we can go on to the next slide now.
Okay. Do you want to comment on that?
Well, sure. Again, these are all clarifying and they're expanding. So this is in the owner's context again. You'll see references there, making clear that we talk about successors to the title of these various potential successor groups. And then you'll see in 5C, D, and E some expansions on the definition of insured to many others that were not expressly addressed in the 06 policy forms, certainly not in any prior policy forms. So again, an area where these new forms should be perceived as improvements from the standpoint of our customers. Next slide.
Yeah, the definitional changes of insureds are selling points for these forms.
Absolutely. The all-important definition of public records. Even though we only use it in a few places, and we only use it in a few of our covered risks even, which means we know that there's an awful lot of coverage built into most of the covered risks that do not contain any limitation to public records. And that's why we spend so much of our time in the underwriting world, especially with commercial transactions, dealing with issues that are off-record risks. But here we have our definition. The first sentence hasn't really changed. It's really more the second sentence where we're making very clear what we always have intended by the definition of public records, that it does not include records in any of these other enumerated filing systems. Sometimes courts have taken the words public records and misunderstood or misapplied them in ways that we certainly did not intend, and we hope this is an improvement in that regard and will serve as a clearer indication to the judiciary what we really mean when we say public records for purposes of our title insurance contract.
Yes, and one of the interesting things about that last sentence is it says does not include any other recording or filing system, including. So the list that follows is illustrative.
That's right. Important to know. Thanks, Jim. Covered risk, excuse me, condition 8. This is an area where, for my money, I would say much of the value of our new 2021 policies will be found. First, you'll see in that second sentence something that also has come into the 2021 commitment to make crystal clear what title insurance is and what it isn't. There are statutes in a good many states that already say this. So this is really just clarifying in those states to make it expressly a part of our insurance contract, and hopefully helpful in other states that don't have those statutes yet, to make clear what we intend anyway to be the limitations of a title insurance contract versus an abstract of title, for example. And then we get into covered risk 8A and B and C. Never before in our title insurance forms have we actually specified the date as of which loss would be calculated. The courts have told us, for the most part, what those dates are. And you have majority rules across the country. You have some differences that represent minority rules. Jim, I would say it's fair that we've adopted in our 2021 forms here the majority rule. We've also clarified when we talk about the difference between the value of the title, that we mean fair market value of the title. That's the all-important diminution in value measure of loss that appears in 8A Romanet 3. We in terms of the timing of when loss will be determined, that is covered in 8B, this being the loan policy. You'll see again the majority rule there in Romanet 1, the date as of which the insured acquires the title as a result of foreclosure or deed in lieu of foreclosure, or in the case of a loss having to do with an assignment, or the insured mortgage itself when it is extinguished or rendered unenforceable. So important clarification that we hope will cut down on a tremendous amount of litigation that's occurred over the years as people have fought about what the proper date for calculating loss is. You'll then get into 8C. This is what we call our cure penalty. We have long been criticized by customer groups for a perception that we want to litigate in an effort to sort of delay the date as of which we would have to calculate loss and ultimately pay loss if we haven't been successful. Well, we don't do that, contrary to popular opinion. Sometimes it just takes a long time, because if we're using the court system takes a long time to make its way through things. However, we did, beginning with the 06 policy forms, see value in offering our insureds some benefit if we do exercise our rights to cure and we are ultimately unsuccessful. And that is reflected in 8C. And the main change there is really an increase in 8C Romanet 1 from 10% to 15%, by which the amount of insurance can grow automatically in the instance where we've exercised our rights to cure and we've been unsuccessful. So that's condition 8 of the loan policy. Any comment, Jim?
No, I would just go forward to the PowerPoint for the owner's policy, because you're going to find similar provisions in some respects. And if you look at the preamble of paragraph 8 of or condition 8 of the owner's policy, you'll see the same language. As Paul mentioned, there are a number of states that either have case law or statutes, but not all, that address this issue. And one of those is California, for example. And then we go down to the question of the determination of loss. If you look at 8B, this is really the majority rule. It's calculated determining the value at the time the insured discovers the defect. 8C is another option. That's entirely new. That would be a matter that's a minority rule, definitely. I know we had a case involving Whitlock where this was essentially the result. So if you have title being void as a whole, you have all of the land, title is void, then the determination at the insurer's choice can be the date of policy instead of the date of discovery.
These are really decisions insureds will make, depending upon, I suppose, Jim, whether or not the property values have generally appreciated since date of policy or depreciated since date of policy. Real estate over time, we all know, has a propensity to appreciate. And so generally speaking, it's in an insured's interest to have a later than date of policy date as of which the loss will be calculated. But in some circumstances, and we certainly saw it at the trough of the Great Recession, it can be the case that the property is valued greater at the time of its original acquisition, aka at the date of policy, than it is later. We do not insure value, that's important to note, but when we are calculating measuring and calculating the loss under a title insurance policy, it is true that the loss is the difference in value based upon the defect insured, or with the defect insured against, versus what it would have been if the defect didn't exist. And so it's in that context that we talk about value and calculating the fair market value of the title at a particular point in time. And we are down to 3 minutes. And so we need to move quickly. This next condition 10, limited to the loan policy, is another very, very important positive change from an insured's perspective, with the highlighted subsection B there. When the title is acquired as a result of foreclosure, the amount credited against the indebtedness does not reduce the amount of insurance in the 2021 forms. This language was not a part of prior policy forms, and Jim, that did lead to a good deal of argument and to some unmet expectations in some cases in a claims context, didn't it?
It sure did. There was differing case law on this, so full credit bids do not reduce the indebtedness. I mean, the amount of insurance. So.
Next slide.
This is a provision indicating that class actions are not allowed. So we see that in both the owner's policy and the loan policy. And to the degree it's enforceable, it is not an optional clause, at least on the face of it, it's not bracketed, unlike the arbitration clause that follows immediately.
Next slide. Speaking of the arbitration clause, it is bracketed, therefore it is optional, and we put it in as the very last numbered condition to make it easier for situations where it is deleted, so that we don't end up with a deleted condition earlier on. It's just easier to just delete the last numbered condition. The brackets, again, signal optional. So each underwriter, we expect, as they go filing their forms, will have to decide, do they or do they not want to have this arbitration clause in the base provision. It can always be eliminated later in most states, of course, by endorsement, which is the way we handle that today. There are some changes to the clause. Read it carefully. The changes are all designed to really improve the enforceability of arbitration provisions to the extent that they stay in. I think that's fair, Jim, right?
I agree. We refer to the AAA rules. You'll see that in condition 18A. We refer to another optional provision, which is bracketed within the brackets. That's in 18D for purposes of the amount of expense will be paid by the underwriter.
Next slide, Jeremy. And we are at the top of the hour, we realize. We apologize if we took a little bit too much time earlier on and a little bit less time here at the end. Jim and I have a lot to say about every line of this, so sometimes we admit to having our challenges balancing out a relatively short 60-minute time period to talk about all this stuff that we've been working on for years and years now. Oh, and this is just in the owner's policy. No comments necessary, as it's pretty much the same. Go on to the next slide, yeah. Jeremy. Here we are. So wrapping up, Jim, you touched on this at the top, that the base owners and loan policy forms, what we've been talking about today, are not the end of our effort as we look ahead to 2021, huh?
That's correct. We had, go ahead.
Go ahead, Jim. No, after you, sir.
Oh, okay. Well, for example, all these forms need to be adopted and available approximately at the same time as we have the base policies, as they're called. We have two versions of the short form residential loan policy: assessments priority and current assessments. That's currently the case and will continue to be the case. We'll have a revised homeowners policy. We'll have two versions of the expanded coverage residential loan policy: assessments priority, current assessments, and two short form versions of that. And then we have a variety of endorsements. You can see the PowerPoint itself on the next page. It'll show you the endorsements that we expect will be revised to be consistent with NU forms.
Right, so the changes we're making for the most part to these other forms and to the endorsements that were listed there are intended to be conforming changes to the extent that the changes we're making to the base policy forms are relevant in the context of those other products, right, Jim?
That's right.
Hey, Jeremy, let me ask a question at this point. I know we're just a bit beyond the top of the hour. I see that a few people have had to drop off, perfectly understandable. I also notice, however, that many are hanging in with us, and we really, really thank you. And I think it's fair, Jeremy, that the recording is going to continue, and that if people are willing to spend just a few minutes more, we're certainly willing. I don't know if you have any questions at this point, or if you have anything else to say by way of wrap up, but I just wanted to touch on that and ask you if my understanding is correct.
Totally correct, Paul. Yeah, the recording's still rolling, and we can just have a little, spend, another 5 minutes, a little fireside chat if people want to submit some questions. We actually have had lots of come in, so, maybe I'll try and sift through, get some of the ones that have the same kind of themes. And if you don't get to your question, right there on the last slide, both Jim's and Paul's emails are on there. Please feel free to reach out to them, and they'll hopefully be able to answer your question. And so yeah, let's I'll just pitch some to you guys. If you guys can maybe just rattle off a quick answer, or answer with a different, answer the question with a different answer. I don't know. All right, I'll kind of work through a little bit the presentation. Covered risk 5. Does it cover a claim by an insured who is not allowed to build a house across 2 lots because of local zoning? Any thoughts on that?
Well, typically you need a zoning endorsement or you need coverage through the homeowner's expanded coverage, the homeowner's policy or the similar expanded coverage residential loan policy, unless there's a notice of enforcement. So if you have an enforcement notice in accordance with our covered risk, then you could have coverage, but we don't typically cover zoning. You see the exclusions that carve out police power and other matters unless the enforcement notice is recorded.
Okay.
And I agree with that, Jim. And I'll just add that obviously determining coverage when a claim is formally made is something that it requires a good deal of thought. Is done by the experts in each of the title insurance companies that are responsible for handling claims and responding to notices of claim. They do a very good job, generally speaking, assessing the facts that are presented in any notice of claim against the provisions of our policy forms and endorsement forms. Are we always right in that initial assessment? No. Do we try really, really hard to always be right? Absolutely. And so it's very difficult to answer those kinds of questions beyond what Jim offered, with which I agree. But again, we take this very seriously. And I think just as a general proposition, Jim's right. We don't cover zoning unless we've issued a zoning endorsement, then limited to the 4 corners of the coverage expressed in that zoning endorsement.
Okay, yeah, good explanation. We've got quite a few questions on the PACA asset exception, and kind of the general question is that with the addition of the covered risk 8, does this alleviate, kind of in your minds, the need for the general PACA asset exception?
Yes, I would say that. That in fact is part of the idea. It's so difficult, generally speaking. I mean, there are definitely experts in our industry that deal with transaction types that are likely to have a PACA-PASA issue associated with them. And for those people, I think they've become pretty adept at identifying transaction contexts where there is a PACA-PASA issue and then taking an appropriate exception in Schedule B. But across the entirety of our industry and across all transaction types, it's just very difficult for people in our business to spot transactions that have any sort of PACA-PASA trust issue associated with them. So that's the reason why we felt it best to add this exclusion. But when we add the exclusion, we also think it's important, just as we did with covered risks 1A, 1B, and 2, in covered risks 5, 6, and 7, to add an express covered risk to which the exclusion does not apply if there's an enforcement notice recorded in the land records. So if we miss it, if it's there and we miss it and we fail to take exception to it in Schedule B, then there's coverage. If it's not there, then the exclusion applies. And we thought that was the right thing to do with this PACA-PASA trust issue. So yes, I would say that once the 2021 forms come into usage, that it won't be necessary any longer to take a Schedule B, a general exception for PACA-PASA trust. That's really addressed by the exclusion.
Okay. And as a reminder, these forms will be going into effect July 1st, 2021. And I think as far as kind of maybe as you see now, there may be some minor changes or tweaks as we get more feedback. Correct?
That is correct, Jeremy.
Right.
Thank you. And again, as Jim said at the top, just because they take effect on July 1, assuming that date does not get postponed, which is a possibility. We've done it in the past, and it's possible we'll do it this time around. It depends an awful lot on a number of factors, not the least of which is our discussions with the ALTA board and whether we can get all the work associated with all the other forms done in time. But our intention is to stick to that date whenever the ultimate effective date occurs. And for right now, that would be July 1 of 2021. That just begins the process that all individual underwriters will then be going through throughout the 50 states, at least those that require the filing of forms or that have a rate bureau approach to their forms in their states, or that promulgate forms, such as is true in Texas as an example. So it'll be an ongoing process where the 2006 forms will remain very much in usage, I would say, Jim, for upwards of at least 2, maybe as much as 3 years in some states. Is that about a fair estimate on your part?
Yeah, and I would say in a few states the new forms won't even be available within that period. So Florida particularly.
Yes. We love our friends in Florida, and we kid with them sometimes because they have the distinction of being the last state that managed to have the 06 policy forms available, but that just has everything to do with the way their regulatory process works and just the time and effort it takes to make through that process. Is that responsive, Jeremy? Do you think?
Yeah, totally. Thank you for that explanation. And we're about 10 minutes after. We still have about 400 people, but we want to be cognizant of everyone's time and getting back to closings or other work you may have. Let's tackle one more question, and it's pretty complex and it probably has lots of layers to think about. But it's in relation to the McGirt decision, Supreme Court in that. And question is whether there's been any discussion about including tribal nations in the governance sections of the policies. There have been the court cases in McGirt. There's other cases in other states involving tribes, and there's separate forms of government regulations that resulted in some underwriters amending ALTA forms to speak to their sovereign status. So would it make sense to address this in policy forms, since it's not just a local issue but affects many states across the country?
Well, thanks for that question. And Jim and I both really appreciate it, and I would say it is a spot on question. 2020 has been challenging for all of us for many reasons. COVID, of course, is one of those, but McGirt is another one. And I assure you that McGirt has driven the Forms Committee to reconsider a number of things. And the suggestion that is being made in this question is one of those things. It is sort of on the list for consideration. I can't predict how that's going to come out when we, finish the work. It is an ongoing process, but it's one of the reasons that several times we've mentioned the possibility, or maybe probability, that there are likely to be a few more changes made. And then that triggers the process once again of, recommendations to the ALTA board, and then the ALTA board's decision to act on the recommendation. And when that will occur in relationship to July 1, is still a little bit up in the air. The board next meets in February, unless that gets pushed into March, which is a possibility. We fully intend on having a laundry list of things referred up to the board by the ALTA Forms Committee for that meeting. Whether or not we'll have everything before the board for that meeting, again, remains to be seen. We're going to try. We're working really, really hard with this within this time frame, but I can assure you that McGirt-related impacts are among a number of things that are driving some of the current discussions that we're having at the ALTA Forms Committee. I think that answers it, Jeremy. Jim, do you have any additional comments to that?
No, thank you. Definitely, you guys are on top of it. Paying attention to market demands, market the McGirt decision. You can see it reflected in the material, remote online notarization. So thank you to everyone on the Forms Committee to be paying attention to these issues and making sure that ands or ors are in the right spot. Just as a reminder.
Yes, indeed.
Sorry, go ahead.
No, I just said yes, indeed, and it's our honor and pleasure, Jeremy.
Just a reminder that the webinar is being recorded. Everyone will get a link tomorrow. You can always go to ALTA's website, alta.org/webinars. You can find our whole archive of webinars. This one will be posted there tomorrow as well. In the email with the link to the recording, you also get a link to download the presentation if you're not logged on, or you can download it now from the handouts section. So with that, I do want to remind anyone, so if you need CE, CLE credit, have any questions about that, please email education@alta.org. Do need to thank First American once again for sponsoring today's webinar. And with that, thank you all for hanging out and a little bit longer today. And that will bring us to the conclusion of today's presentation. Everyone.
Thank you.
Thank you, Jeremy. Thank you, Jim. Thank you
Appreciate
all of our participants. We appreciate you.